Well, good morning, everybody. Thank you for joining us today. We've got a wonderful panel here assembled to talk about some of the 2025 employment law changes for not only the upcoming year, but into the future here. So with that, I'd like to start with introductions. My name is Billy Doherty. I serve as the president and general counsel for Doherty DAHL. Been with the company and within the industry for over 15 years, focusing on a variety of workforce solutions and employment services spanning light industrial, professional IT, and everything with consulting and MSP. Today, very excited to be joined by Leah Elliott. Leah serves as the co-managing partner and stakeholder of Staffing GC. It's the first of its kind law firm providing staffing companies with legal services. She's an attorney and C-suite advisor with more than 20 years of boots on the ground experience in labor and employment law and the workforce solution and staffing industry. And we're also joined today by Melissa Jaden. Melissa has nearly 20 years of experience within the employment sector. As the human resource senior manager for Doherty DAHL, she focuses on talent acquisition and retention, policy development, employee relations, and performance management, as well as administration of compensation and benefits. So the topics that we have assembled today really, I believe, are pretty pertinent to the discussion as it relates to the employment landscape across Minnesota and on a federal scale too. So what we're looking to do is talk first and foremost about the Minnesota Pay Transparency Act that's set to go into effect here the first of the year. So want to talk about considerations in anticipation of that and really the duties from an employment perspective and employer perspective from an ongoing perspective. The Minnesota Paid Family Medical Leave Act, want to talk about that. That goes into effect now the first of the year in 2026, but there are considerations from an employment perspective you want to be making for 2025 leading up to that change. We'll be talking about pregnancy and parental leave changes, both on a state and federal level. Talk about the amendments to the Minnesota Earned Sick and Safe Time, the ESST law that went into effect now the first of last year. There are some changes that are coming into effect. And then also want to talk about the employer drug testing policies for Minnesota. The one thing that you won't find on this agenda topic list, but we will touch on, is that on November 15th of this, about a month ago here, the U.S. District Court of the Eastern District of Texas vacated and set aside the U.S. Department of Labor's final regulation, which is set to increase the salary threshold for white-collar overtime exemption under the Fair Labor Standards Act on a national basis. So really what this means most notably is that the increase in the overtime threshold that was scheduled to become effective on January 1st, 2025 will no longer be going into effect. The court also struck down the July 1st, 2024, a couple months ago, increase that had previously went into effect. So this probably should have limited practical effect for many employers that have already adjusted their payroll, but the upcoming adjustment will not be going into effect. So finally, the court also held that the automatic escalator provision, which would have increased that threshold every 3 years going forward, was also unlawful. So that was almost going to be the topic du jour for today, but with a vacated finding with that, we'll be concentrating on these agenda topics. With that, we will have the Q&A available all throughout. Please send us questions along the way. We'll wait until the end of the discussion here to be looking at answering ideally as many of those as we possibly can. So with that, I'll turn the presentation over.
Good morning, everyone. Welcome. We're excited to have you here and talk about the laws that have been coming down the pipeline for the state of Minnesota specifically. And one of the newest ones, we're joining other states as it relates to the Minnesota Pay Transparency Act. So coming January 1st, hopefully for those of you that are HR professionals on the call, you've already started to do some preparation for this. But this applies to employers with 30 or more employees, are required to, as of January 1st, so you need to have your postings, your job postings up to date by January 1st to include compensation and benefit information. So salary range disclosure, and this is a good faith estimate of the salary range or fixed rate. However, the rate cannot be open-ended. This would be a violation of the law. So either a range or a fixed rate for the position. It also must include a description of all benefits associated with the position, including health and retirement benefits and other compensations such as commission or bonus earnings. The broad definition of a job posting under the state law is that the law applies to any solicitation intended to recruit applicants, including direct recruitment and posting by third parties, regardless of the format. So what this means is if you are posting out on social media sites such as Facebook, LinkedIn, other social media entities that aren't your traditional job boards like Indeed or Glassdoor, that you need to include this information in those postings as well, or at the very least, include a link back to those job postings. One thing you want to keep in mind is train your managers and make sure your HR teams are aware of the expectations for their job postings, that this information is required. And then for those of you that work with third-party staffing services such as Doherty Staffing and DAHL Consulting, the staffing companies that you work for are also required to post this in postings that they post on behalf of a client. So ensuring that you are communicating with your staffing partners expectations around pay, benefits, so this can be included in those job descriptions and postings as well.
Yep, and that's quickly, Melissa, to add on with respect to a little bit of the national perspective on this. While pay transparency law is new and coming to Minnesota January 1, it has been in effect in several other states at this point, right? We have about 12 to 14, maybe 14 states now with pay transparency laws, varying definitions of thresholds, how many employee, what the head count is, what's included, that type of thing. But this is very similar to what we've seen across the board, and can share just a little bit of the activity that we see in other states that we might expect to see come about and bloom in Minnesota as this law matures after it goes into effect. And I can share that one is that the concept is relatively new, right? Colorado was the first state in 2021 to pass a pay transparency law. All of our heads kind of kaboomed a little bit, and that's when we saw a lot of companies exclude Colorado applicants because they didn't want to have to post for positions to include pay transparency then. Now it's becoming more commonplace, and the norm nationally is to include pay ranges more so than not. So we are seeing a more of a shift, and relatively quickly in terms of for it just going into effect in its first state just 3 years ago. We aren't seeing much in terms of penalties and enforcement. Outside of Colorado is the only state that publicly disclosed that they've issued penalties and fines. So, I do think you will see enforcement sort of light on the front end to give employers the opportunity to catch up and comply. And after the Department of Labor and Industries decides that you've had enough time to comply and become aware of your obligations, that's when you'll start to see enforcement kicking in. And then beyond those regulators, we also want folks to be cognizant of the fact that this is a space that we've seen class action kind of sharks swirling around a little bit, right? So, they're always out there testing the waters and looking for new ways to grow their own businesses and their own law firms. And so we have seen some class action firms out on the West, class action cases out on the West Coast primarily with regards to, ranges being too broad or not including ranges. But there have been a couple favorable decisions that I think make sense and we should see replicate. We'll know for sure as other courts, as these laws mature and other courts interpret them. But one thing that seems very common sense to me, and that at least one court has agreed with, is that an applicant can't just bring a claim against you because you didn't include the pay range. They have to be a bona fide, legitimate applicant. So, we have to get rid of the notion that we can all quit our jobs and start perusing the job boards and sue all the companies because they didn't include job postings, right? If we could do that, that would just make a killing, right? But the employers are saying the casual browser online looking for non-compliance is really not suffering a legally recognized harm. So we should see a decent amount of that. And beyond that, this concept really is here to stay. We are seeing a lot of societal and social demand for it and around it. And so this pay transparency law, while it does require some tweaking to the job postings and to some, internal, reviews with regards to how this might be received by your internal employees, right? You want to look at your own internal pay equity data to see if you're hiring people brand new who are being paid as much as someone who's been there for a few years, you want to be ready to acknowledge and deal with some of those types of challenges. But compliance should be relatively simple to switch on. And like Melissa mentioned, goes into effect in the state Jan 1.
Now moving on to Minnesota paid family and medical leave. This law does not go into effect until January 1st of 2026, but there are a number of things as employers that we need to do to prepare for this upcoming law, so we're ready for it. If you've been following this at all, you will know that this law doesn't necessarily follow traditional FMLA and what qualifies. It's a little different than the law, and it's a little bit different than the Earned Sick and Safe Time plan as well. The two components of the Minnesota paid family and medical leave is family leave, and this is to care for a family member with a serious health condition, or if you are bonding with a new baby or child in your family. Under Minnesota state law, the list of who is considered family is more expansive than FMLA. It includes spouse, domestic partner, child, whether that's adopted child, a biological child, fostering, stepchild, legal guardianship, local parentis, de facto parent. It also includes your in-laws, son-in-law, daughter-in-law, grandparents, and then anyone who you would deem as having a relationship with that creates an expectation where you are the primary caregiver for that individual. And there isn't a definition of what that means, just that the person does not need to reside with you. And then medical leave when your own serious health condition prevents you from working. So that one is very similar to what applies in FMLA. There is no requirement as far as the number of employees that an employer needs to have to offer this benefit. So basically it applies to all employers, and this again goes into effect January of 2026. And a couple of the things that have been on the docket in 2024 is the increased payroll tax. The payroll tax on wages increased from the 0.7% to 0.88%, with a potential cap of 1.2% for future increases. Small employers may qualify for a reduced rate of 0.75%. Hoping that this is going to be the 0.88% is going to be the percent going into 2026, but that could still change between now and then. Again, expanded coverage for self-employed individuals and independent contractors. They can register for these benefits as well. Employees transitioning from private to state administered plans retain benefit entitlements. And then it replaces your wages. So total compensation during leave, including employer-provided wage replacement, cannot exceed the employee's regular pay. There hasn't been anything released as far as how this will interact with existing employee-offered short-term disability, salary continuation, parental leave plans. I do know that it is a requirement by the state that all employers enroll in the paid family and medical leave plan. So if you have a plan that pays at 100%, you still need to enroll and participate in the state offered plan. And then some key milestones between now and 2026 that employers should be aware of. If you're not already aware of this, quarterly wage reporting began in October. And If you're set up in the unemployment system, your wages are automatically reported through that. Some religious entities would have had to go in and set up a plan through the state of Minnesota. But for the majority, if you were set up with the unemployment program, it's automatically being reported. Throughout 2025, you should really be assessing whether or not you are going to go with a state-sponsored plan or look to have a private administered plan. And right now, the state has not approved any private plans. I gather that that will probably happen sometime in 2025, and you'll be able to make the determination. If you do decide to go with a private plan, you do need to submit the information and get it approved by the state. One of the benefits of having a private plan is that you will be the one that has access to the information as opposed to the state. I think there's going to be some challenges in the future with employees submitting information to the state and maybe the employer finding out after the fact that someone is needing a leave because it's going directly to the state. Also, in July of 2025, there is a period to apply for outreach grant funds for those smaller businesses. And then December of 2025, there is a deadline to notify employees in writing of the Minnesota Paid Family and Medical Leave. The state is going to have some type of template that employers can use. So look for that in the future to be posted. And then January of 2026 is when individuals and families can begin taking leave. And this is when they can begin to receive payment for that leave. And then in April of 2026, employers' first quarterly premiums are due. To stay up to date, get information, get emails on this, I would recommend subscribing to the paidleave.mn.gov website to get your regular updates as things come down the pipeline. 2026 is going to be a big year, and 2025 is going to be the year to prepare for family and medical leave. Pregnancy workplace changes. So Minnesota has made some amendments in August of this year related to the pregnancy and parental leave workplace accommodations. The amendment was that pregnant employees in Minnesota can take prenatal medical leave and it won't count against their 12 weeks of parental leave. So they can be excused from work to take those times to go visit their doctor. And then another addition to that is the continuation of benefits. So employers must continue providing benefits during leave, similar to FMLA requirements, where benefits have to be covered through those 12 weeks while on leave. Impacting smaller employers not previously covered by FMLA. So those employers who have under 50 employees that may not be have to adhere to FMLA regulations do have to continue benefits while a person is out on leave under the state pregnancy and parental leave workplace accommodation.
Thank you, Melissa. And I think that probably with the paid family and medical leaves gives you a quick preview of what is probably going to be on the agenda for next year's annual update from Doherty. So we can expect lots of updates there. I did want to just really quickly address a couple little questions that I saw come through. One is around the pay transparency and which employers it applies to, and it is for employers with 30 or more employees, right? So that's that is the threshold there for that requirement. And then also there were a few questions around the level of detail with respect to benefits that need to be included. And the law says a general description, right? It doesn't go and give us a lot of detail. So what we see in other states, what I would say to watch for is, at least provide that general description of the broad categories of benefits that you are offering for that role. And then what we could see, and what we have seen in some other states, is that when the rules come out through the regulators, which aren't out yet, but we could potentially see guidance or some rules come out from the Minnesota Department of Labor and Industries that might permit you to provide a link So if your benefit categories are the, consistent across very big swaths of groups of employees, that can sometimes be a helpful way to avoid, getting it all typed out and having a really congested job posting, so long as that link includes publicly available access that's, readily and easily available to the applicants to be able to view what those benefits offered are. But unfortunately, it's a little bit of a wait and see. But in the meantime, a general description with a list of those, at least including medical and 401k or retirement plans. Those are the two that are specifically called out in the law itself. And so switching here to the Pregnant Workers Fairness Act, right? This is a federal law that was passed in 2023. It went into effect just about, just a little over six, just not very long ago, right? Just June of 24. And employers are required under this act in all states, right? So Minnesota and everywhere else, to reasonably accommodate pregnant workers. They're required to provide light duty to pregnant workers, and this is extending not only to pregnancy, but also to childbirth and related conditions such as fertility, stillbirth, termination, and miscarriages. And what I can share on this is that the EEOC is hyperactive in this space right now. We are seeing a lot of activity. And I think that was a typo on the last one. The effective date of the Pregnant Workers Fairness Act was 2023. So we're just about 18 months into this law going into effect. The EEOC has already filed 5 lawsuits against employers, right? They are very interested in this. It is low-hanging fruit in their experience so far. They've settled several. And if you've been involved with any investigations or lawsuits with the EEOC, you know that when they enter into a settlement or they file a lawsuit or they receive a verdict, they're very chatty about it, right? They push it to their newsroom, right? So you can look at the EEOC's newsroom on their website, and you can see that they are absolutely going after this. It's taking up a lot of space in terms of their initiatives for the fiscal year. It did last year, and it will this coming year as well. And what this is requiring is that employers accommodate pregnant employees, right? Just like it suggests. And it goes beyond ADA, right? So I wouldn't just apply the Americans with Disabilities standard to reasonable accommodation, because the regulations and the law have gone further than that and said there are certain accommodations that we are 99.9% of the time going to be deemed reasonable, and that you as an employer will never be able to prove it's an undue burden to extend it to a pregnant employee. And that's in large part because they are viewing these as very temporary restrictions and accommodations, because as far as any of us know, I've not met a woman who's been pregnant into perpetuity yet, but you've got a 9-month window on that. And that, I mean, I know it feels like it goes into perpetuity, but it really is just a fixed period of time. And so these are examples of what the EEOC is going, if someone is terminated, retaliated against, demoted, or some sort of adverse action is taken against them because they're requesting one of these accommodations, you can expect the EEOC to come pretty full force at you to try to enforce and reach a resolution on a charge that will be filed. So things like breaks for water, restroom breaks, the ability to bring water, a bottle of water or a snack into a work environment, right? Those are things that are just kind of pregnancy 101, right? Those will be deemed reasonable. Changing their equipment, like providing some sort of like a seat or a stool to sit on, or a way to perform work standing up if sitting is the problem, right? Changing the uniform. These are very prime examples. One of the last one on that, right? Leave for the medical and healthcare appointments, very important. Extending light duty to them for that temporary period of time, always going to be considered to be a reasonable accommodation. And when I advise clients in this space, when they call and ask, and say my employee is expecting, here's the things that they're requiring. I don't know if I have light duty. I don't know if I have this. I'm not sure how to do this or that. I think it's an undue burden. And here's the reasons why. The only way that you're going to satisfy an EEOC investigator and potentially a federal judge, honestly, under this law, because it is broader than the ADA, it will only be an undue burden if you grant it and it puts you out of business, right? If you giving that employee an extra restroom break or letting them perform light duty doesn't throw the company into bankruptcy and put you out of business for all of time, it's going to be really difficult to argue that it is an undue burden to the organization. So all the potential impacts, the perceptions by other employees, all those kinds of things, the judges and the investigators are not going to give any weight to, right? They're really looking at it case by case, company by company, right? Specifically looking at whether or not it will really put you under if you accommodate it. So it's got to be very, very significant expense or difficulty. It also restricts the ability on, your ability to request medical documentation. You cannot request medical documentation for water, additional restroom breaks, rests, or kind of food breaks, permitting food and water, right? That's, like I said, everybody thinks that's pregnancy 101. You shouldn't force someone to go to the doctor to get a note that says that, right? We probably all know that by now. And then there's also the continued, like there is under ADA, the requirement to keep information confidential, right? The medical information needs to be maintained confidentially out of respect for employee privacy. Now, like I said, we have seen lawsuits filed, and five of which have been filed so far by the EEOC. A few are still pending. One immediately settled, right? So there was one in the Southern District of Florida against a large resort, and the employee had filed the lawsuit because her employer denied her request for leave after she suffered a miscarriage 5 months into her pregnancy. And she requested time off for both healthcare appointments and to grieve. And the employer immediately settled the lawsuit with the EEOC. But just to give you an example of what the EEOC will push for in settlement, that employer, one, had to pay $100,000, right? That's just a given. They're going to pay some sort of monetary settlement to the charging party. Secondarily, they paid all the attorney fees, right? That's a whole separate hearing on how much attorney fees were drawn up, and they're responsible for paying that. But they also have signed a consent decree with the EEOC and agreed to hire a full-time EEO coordinator whose full-time job at the employer's expense is to ensure that the employer is aware of its reasonable accommodation responsibilities and making those available and reviewing and engaging in the interactive process appropriately with employees when those situations come to light. And this is the real doozy to me. This is new. I haven't seen this in any other EEOC charge kind of subject matter. And that employer is required to directly notify the EEOC each and every time they receive an internal complaint of discrimination in the workplace, right? That's broad. That's not just every time someone who's expecting is saying they weren't accommodated, or every time someone's requesting. It's every single time you get a complaint in, right? So really it can be, compliance is definitely the way to go on this one, I guess is what I'm saying. This isn't just you get sued and you pay some dollars and you settle it, right? The EEOC is really, really trying to make examples of organizations at this point to really drive the enforcement and the compliance piece there, because they really feel it's not fair to require expecting mothers to choose between making a living and attending, prenatal healthcare appointments, and, taking care of themselves versus making a living. And so this is one that's, we're going to continue to see an awful lot of activity around. The other lawsuits that are pending are kind of scattered around the country. They've all revolved around failure to accommodate. One was not permitting an employee to be excluded from mandatory overtime when her medical provider said she needed to be limited to 40 hours per work week. She wasn't allowed to leave for medical appointments without incurring attendance points. So that's one of the lawsuits that's pending. Another one, an employer refused to allow an employee to have a stool on the line to sit at to take breaks as needed. There was another that refused to allow water on the work site, right? So all these things, right, straight from that original list of these things, that what is the EEOC always going to consider to be a reasonable accommodation? And when you deny them, you do so at your own risk, right? So very important to make sure that you're not only aware of those, but that your frontline managers can issue spot this if and when the situation arises, and just escalate it to the appropriate context, either within employee relations or HR, right, to make sure the situation is managed to a compliant end result.
Now, a little bit about ESST. We're almost a year into earned sick and safe time law in Minnesota. Hard to believe, last January, we were rolling out this new law, and everyone was trying to wrap their mind around how this was going to work for their staff. And as we've seen, the state has made some amendments to the ESST effective May of this year. They rolled out some new changes. One, which I'm sure a lot of you probably scrambled to ensure that our requirements were on pay stubs and reported properly, where employees had access to that information. Well, the state of Minnesota has decided that you no longer need to provide information about ESST hours that have been used or earned during the pay period on a pay stub or an earnings statement. So you can choose a reasonable system for providing information at the end of a pay period. So if that is your payroll system that you have, that they have access to real-time information, or another form of electronic communication, but do know that you no longer need to include this information on earnings statements or pay stubs. They also went on to clarify what covered employees means. It means that the employee is anticipated to work at least 80 hours in a year for an employer in Minnesota that is covered under the ESST. And if you recall, all employers ESST applies to regardless of your size. So if you have one or more employees, you are covered and should be offering ESST to your employees. They also updated the increments requirements. Employees may use ESST in the same increments of time for which they are paid. Employers are not required to allow employees to use ESST in less than 15-minute increments and cannot require use in more than 4 increments. So just providing some clarification around what can be requested by employees for time. Documentation. The law still maintains that the original documentation requirements, however, they did clarify the calculation of 3 consecutive days off must be calculated based upon scheduled work days only. So not 3 consecutive days that includes a weekend, but 3 consecutive work days. So take a look at your policies to ensure if you have a PTO policy and your PTO policy is more generous than the ESST law, making sure that those PTO policies align with the ESST, asking that you can't ask for the doctor's note until 3 consecutive days of being out related to illness. So making sure that you're complying on a documentation standpoint. Base rate calculation, there was some confusion around what was considered base rate. So the ESST pay is calculated at the employee's base rate, excluding higher rates for overtime or weekend work. So what their true rate of pay is, not including overtime or weekend work. And then another addition was funeral leave. Funeral leave is now protected under ESST. An employee can use ESST for bereavement purposes, including making funeral arrangements, attending services, and addressing legal and financial matters after a family member passes. What is defined under the ESST is the family member, so immediate family members or one individual that they identify as a family member. And then Leah, I'll hand it over to you.
Yeah, it's a very broad, right? I mean, who is considered a family member is a very vast group, right? Like Melissa mentioned earlier, can include step, adoptive, guardianship, in-laws, foster, right? All those relationships, plus that catch-all to me is kind of the critical thing to always keep in mind, is that the employee can designate up to one person annually that they want to be included in that category as a family member, right? So important to know that that's also a possibility. Just very broad strokes, really removing, I think the state's just trying to remove the ability for employers to get too technical with the approach. They're trying to make it flexible and as broad and available to employees as possible without, employers digging into what the actual relationships are and, asking for birth certificates or marriage records or all that kind of stuff, right? So it consistent with employee favored type law that we see in other jurisdictions as well. And one of the questions that we receive that I get from a lot of clients, and that we see across the country with other states that have paid leave laws, whether it's for sick time or for any reason, is what about our current internal paid time off policy, right? It might be generous enough that it meets the amount of time you're required to grant to employees, and including for the reasons under the new various state laws for that paid time. But something that's coming to Minnesota effective January 1 to keep in mind, and this, a lot of employers, not a lot, but maybe they've up to this point blanketed under one PTO policy. And employers starting January 1 need to have a look at that internal PTO policy if you're using it to satisfy ESST obligations. Because if you are, then then all the hours available to your employees under that paid time off policy they must meet they're subject to the same requirements that ESST puts into place, right? So Melissa talked about the increments within which employees can use time off. Between 15 minutes, they can't go any lower than that. And then you can't require them to use anything more than in 4-hour increments. If your PTO policy mandates that your folks use paid time off in 8-hour increments, it will not satisfy ESST requirements and you'll be out of compliance, right? So very important to have a look at if you're using your PTO policy to blanket and satisfy the requirements under ESST, look to make sure that the various requirements around the notice, the anti-retaliation, the increments of usage, the documentation, right? We talked about you can't require a medical healthcare providers or a document unless they miss 3 consecutively scheduled work days. Those will all have to be plugged into and applied to the entirety of your PTO policy starting January 1 if you want it to satisfy both. So you either want to look at that, plug those in, or consider how you parse out ESST time, right? It's a little bit of a balance there of how much time do you take out of PTO to allocate. It involves, some pretty intentional planning, some thinking, looking at how time is utilized, but definitely want to review those policies and make sure that you're not just assuming that because you offer, let's say, 4 weeks of PTO for any reason at all, that's not the only requirement that your PTO policy needs to meet. It also needs to meet all these intricate, more detailed requirements under ESST law in order to qualify as a compliant offering to your folks. So please do have a look at those if you're operating under the assumption that your policy is more generous and already, applies and covers these.
So now I wanted to talk about the changes that we've seen from the employer drug testing policies within Minnesota. So well, over a year ago, Minnesota allowed for the recreational use of cannabis, and now Minnesota is one of 23 states that allow for the recreational use. And so under the Minnesota Lawful Consumable Products Act now, it allows for individuals within Minnesota to consume alcohol or cannabis on their own time and really not suffer any adverse employment decisions or, kind of effects from the use off hours. So with that, then I think downstream, they took a look at the Minnesota Drug and Alcohol Testing in the Workplace Act, DATWA, to look at how companies are administering drug tests and taking a look at the barriers to employment for a lot of individuals that we saw from having a policy that mandated that you'd have to go through a certified lab for a test that would require somebody to schedule it out and actually go to the physical lab for that test. Historically, the certified lab, many large employers had those labs on site. Whether that truly qualified as a certified lab was, I think, a little bit up for debate. But the problem was the overarching body that took a look over the enforcement that was the Attorney General, and it never seemed like the Attorney General was interested in that. So it was more so just a plaintiff's playground from a plaintiff attorney perspective to look at that. So they really looked to standardize that. And so with that now, effective August 1st of 2024, oral fluid testing is now allowable within Minnesota. And that puts us in line with North Dakota, South Dakota, and Wisconsin. Iowa's a little bit different. But with that now, no longer do employees need to go to a certified lab for a test. You can have a oral sample test that allows for almost instantaneous results on premise. And so with that now, the oral testing would now state that if you do administer an oral test, the individual must be informed of the results immediately, which is pretty simple because those tests, within a pretty short condensed period, would be, showcased on the little tube that you put the saliva sample in. But with that, if an individual tests positive based upon the number of panels that you have within the test, 4-panel, 5-panel, 10-panel, they can request that a certified lab perform a retest, or they go in to do another test within 48 hours. That would be at the employer's expense. However, now if they go in, if they test positive with the oral test, if they go in, they test positive again at the site, and again seek to retest their sample, they can, under law, again seek to reset or retest that same sample that they provided on the premise, but now that would be at the expense of the employee to have that retest take place. So the feasibility of somebody, after 3 strikes here, continuing to maintain that they aren't actually under the influence, probably unlikely, but for whatever reason, that was included in the law. So again, the wave of cannabis use from a recreational perspective is really happening fast and furious. They are talking about, the declassification of it from a federal narcotics perspective. Whether that'll be accomplished or not remains up for debate. But that is something that we really believe that employers should look at pretty heavily, because I think a lot of employers will talk about the desire to continue to have cannabis as one of the panels from a testing perspective, citing the safety sensitive portion of the law that allows for that against the positions. But I think a lot of employers run into a bit of a mistake, casting that as a bit of a broad umbrella to state, well, there's going to be a safety element involved. Really, I think we can classify it as such, but I just want to be careful to really look hard and critically saying, again, would the use of marijuana really put that person in a truly safety sensitive, kind of position where they could truly provide, or, not only cause harm to themselves or to others. So if you're talking somebody really on a line or assembly line or something like that, could they really, by the nature of them being under the influence, really, pose a threat to themselves or their coworkers? And I think that is going to be the continual focus of this as the marijuana or cannabis usage becomes more prevalent. I think that will be an element of enforcing. But again, it's a very fact-specific type of a judgment that needs to be made by every single facility, and that really is up to you all.
Got
And so
some key takeaways, right? There we go.
pardon?
I said we got some key takeaways.
You want to take that, Leah?
No, go ahead.
So the key takeaways are the FLSA or the overtime rules. Really taking a look at the pay transparency. I know there are a couple questions as it relates to what that means and the nuances against that. I think Leah spoke a bit to that, but if there truly are nuanced questions that you have against your own internal policies, I would ask or state that you should talk to your internal counsel or outside counsel based upon the number of different job postings that you're making, the nuances of the roles. You're talking about the compensation, the bonuses, the commissions. Those are going to be very company specific. So it really would behoove you to speak to an attorney to talk about that, to set the guidelines for your internal team, assuming that you have a very standardized practice by which you're posting those jobs, that it's not based upon a branch or it's not based upon a localized level. Really certainly would be worth your time and effort. And then the changes to the Paid Family and Medical Leave Act. Again, as Melissa showcased, some of the differences that are happening here over the years, some of the reporting requirements from an employer perspective, and the fact that, yes, in 2026 now, it will be a very prevalent part of the employment landscape within Minnesota. So I guess depending upon your stance here, there are a lot of new employment law nuances to Minnesota. We're certainly at the forefront, it seems, with a lot of those. And so with it requires a lot of time and effort and energy to ensure that there is compliance across the board, because it's very easy to trip up or to really get in trouble unknowingly, but we're trying to highlight and showcase some opportunities for you to look critically at your internal policies, at the guidelines that you have internally, handbooks that you have internally, and really try to set that foundation to ensure ongoing compliance.
For pregnancy and parental leave, just a reminder to make sure that you're reviewing your policies, not only from a state level, but from a federal level, to ensure adequate coverage for extended leave periods. Connecting with your HR team when it comes to making decisions on disciplining someone that is pregnant, termination of someone that's pregnant, accommodations, communicating with your HR team, external counsel, internal counsel if needed, before making any decisions related to accommodations and pregnancy in the workplace. And then ESS, oh, go ahead, Leah.
Oh, I was just going to say the ESST law, you want to make sure that you're having a look at your internal policies, make sure you've got adequate coverage in place for leave periods. And like we mentioned earlier, around your because of the modification coming into the amendments that were passed coming in January 1, if you're using your current internal and voluntary PTO policy for purposes of satisfying ESST, make sure you have a second look at that you don't have some sort of criteria or requirement in there that would somehow disqualify that from counting. I did want to add quickly that some of the questions that I've seen in this side chat around pay transparency and what is and is not considered compliant, and it's very hard for us to say with certainty what it absolutely is, what that range is. Is it 10%? Is it 20%? But we can tell you who's gotten caught and for what, right? And who they've deemed have gone too far. And so we do have, I've got, in New York City has a similar pay transparency law, and they're a relatively aggressive enforcement agency in New York City, right? They're pretty activist out there and very enforcement oriented. And they brought claims against some big employers, one of which was the holding company for the Wall Street Journal. They had advertised a position for a reporter. It had a pay range of $50,000 to $180,000. That doesn't fly, right? They said that's too much. That lacks credibility. And likewise, on the hourly piece, they brought a lawsuit against Tesla, who was recruiting for and posted a job for a service technician, and they listed $22 to $60 an hour, right? Not by itself, without any explanatory context. It may be that it may be legitimate that range does exist, but without any additional information to qualify that, right? They're saying these broad ranges are going to be frowned upon beyond that, it's very difficult to then manage your candidate expectations when you do get people apply, to help them understand why they're not getting 180,000 and instead they're getting the 50,000, right? So just some examples of at least what we know is probably not going to satisfy kind of that taste test.
And then from the employer drug testing policy, like I mentioned earlier, there was a side question that stated, you know, do federal contracts adjust the testing standards when it comes to the THC testing? The short answer is very likely yes. That would be a question for your internal counsel too. Again, is, you know, does that federal contract, you know, relate to the entirety of the work at that facility? Is it, you know, is that person in that job, you know, subject to that federal contract? Obviously with THC being recognized as a federal narcotic. So the nuanced answer is yes. But again, that would be a question for your internal or external counsel as it relates to that individual in that individual position. Are they performing work against that federal contract? All right, well, had a whole slew of questions here, so we'll try to start knocking them off. I know along the way we've touched on a few of them here, but try to find some of these questions with some commonality. So, first one here, do employees need to reside in Minnesota to be eligible for Minnesota ESST? And the answer is no, that the employees do not need to live in Minnesota, but they need to be working in Minnesota. And that's a big nuance. And I think COVID has really highlighted that, and we've seen that internally here too. What I would say is that employers need to really be looking at your handbook to stipulate, you know, it's a lot of times we'll see individuals start an assignment, maybe they'll be working in Minnesota, but if it's a truly you know 100% remote position, what would preclude them from going to Wisconsin? You know, what would preclude them from starting to work in another state? And again, ESST, much like we saw when the Earn Sick and Safe or nuances within states or cities, we're talking about time spent working in those cities. Same thing with Minnesota. So if somebody starts their job in Minnesota and doesn't tell you, and then all of a sudden they move to Iowa, you know, the hours that they're working while they're working in Iowa would not be subject to that. So really ensure in your handbook that you have the guidelines that stipulate, you know, the in essence, the way that they need to communicate the potential move, you know, how your stance would be on them choosing where they're performing the work, and just have that front and center. So they're, you know, after the fact, you're not caught in a position, or, you know, conversely, you believe that person starts working in Wisconsin, and suddenly halfway into their assignment, you believe the last, you know, 4 or 5 months, they've actually been performing work in Minnesota. That's going to be problematic.
And even outside of ESST, right, Billy? I mean, it would be, you know, where the employee is working from is important on multiple levels, right? If you've got somebody that you want to make sure that if you have a remote workforce or hybrid, that you put the obligation on your employees to notify you if and when their state of primary residence changes, because as a very general rule of thumb, and there are some exceptions, but the law in the state in which your employee is working is the law that will apply. And so if you have someone unbeknownst to you who's relocated to California, you know, there's a whole host of laws that might come into play, some of your policies that might be impacted and affected. So very important to have current data on remote employees.
Right. Well, how do all these leave laws impact our point-based attendance policy? We have a policy that assigns attendance points when an employee is late or misses work. We do not ask for the reason for the absence or tardy. Are these policies still legal?
Yeah, it's a good question. It's point policies were popular for and still are for a very long time, right? It kind of sourced from when employers had fault and no fault policies, and then we moved to this no fault structure because the management of fault versus no fault attendance occurrences was administratively burdensome. So, you know, we kind of moved to here's a swath of time, take it. I don't care why you take it. Once you're out, right? And what's happened in the last 15 years is that data is showing that there's a disparate impact with the application of that policy, which is obviously very neutral and not, you know, discriminatory at all on its face, but has a disparate impact on people with disabilities, with medical conditions, people who are pregnant, people who need protected time off, those types of situations. And so you can have a points policy, but know that you have to have a lot of exceptions to it, right? And so to that extent, you want to make sure that the policy, both as it's written and as it's enforced, doesn't penalize employees for attendance occurrences that are protected, whether that's protected under federal law or under state law, or even, cities and municipalities have protected leave laws. So, because if you do just apply it across the board, what tends to happen is your own internal data will support the disparate impact charge that gets made. And that's the challenge there, is that if we don't apply some sort of fault, quasi-hybrid fault, no fault policy to, blend it into this attendance point policy, it really increases legal risk, because there's always going to be a good number of employees who point out, because of medical conditions, because of pregnancy, because of a denied reasonable accommodation, right? And that's where we see regulators and enforcement agencies zero in and target. So there's nothing illegal about an attendance point policy, but just know we're kind of at that turning point where the exceptions are a little bit starting to swallow the rule, right? It's not nearly as neutral and hands-off, and can't be without increasing legal risk to employers.
All right, so how will the pay transparency law be enforced? Are there monetary fines?
Yeah, we don't know yet, right? They haven't, so the law has not plugged those in. I would be surprised if there's not some form of penalty associated. We know that employees can file a charge or a complaint with the Minnesota Department of Labor and Industries. We know that department and/or the Attorney General's office in the state can enforce it. Penalties have not been scheduled and laid out, so we don't know what the cost of noncompliance is, with certainty at this point. There is a private right of action option that exists. So to the extent an individual party could prove damages, that could be a measurement of some sort of consequence in terms of a claim that's filed. But I really think we need to keep an eye out on the department. I know Melissa mentioned earlier getting on, the kind of the email lists, and those are so important, and getting updates. I do think the state really does a great job at pushing information and trying to proactively help to educate employers to be compliant, which is actually very refreshing compared to some other states who kind of do a kind of lie in wait and catch you kind of situation. So, we really have a lot of resources available through they're pretty transparent with their own data and information. So watch for, guidance to start coming through in the next year as this law goes into effect. Beyond that, it really will kind of be a wait and see to see who experiences charges and what the consequences of those charges are, as we start kind of narrowing what it means to be compliant under this new law.
And generally speaking, I think a lot of times when we see some of these new laws come out, the state will take a bit of a wait and see approach, not to come down with a heavy hand early on. I think short of just willful defiance or malicious intent, that relates to this, there's a bit of a grace period that comes with it to really allow for people to adjust, to really kind of make the mistake of, we were trying to make these things happen, but, based upon the size of your internal team, there's an element of, trying to educate your employees, trying to put the policies and procedures in place and ensure that people change their behavior based upon that new law that came out. So that's not to say don't, really kind of turn a blind eye and, just kind of go, well, we'll see what happens. But just, the perception would be that early on, a week into it, that there's not going to be monetary fines that are flying all over the place. But again, if you're just continuing to just not even try to adjust, I think that will be problematic. So, well, with that, want to wrap this up right at the end of time. Again, thank you for everybody for attending today. We will make the webinar available after, and look forward to probably doing this again next year. Had a wonderful wonderful attendance here for the last couple of years, and we'll continue to be doing this. But if you have any comments or questions as it relates to additional content you'd like to see as we move forward year over year, we'd love to hear it. Again, I look forward to working with everybody, and have a happy, wonderful holiday season.
Thank you.